This is the last of the Fulfilling the Commitments Beijing Plus 25 free online course. It's being held by UN Women, ParlAmericas, the University of the West Indies IGDS Dame Nita Barrow unit based in Cave Hill, and all of the fantastic women who have been supporting this process for us. The first module, as you know, was done by Barbara Bailey and Professor Bailey, and it was on women and poverty, education, the training of women, and women in the economy. The second module, led by Ms. Roberta Clark, was done on violence against women. The third by Dr. Rosina Wilshire on institutional mechanisms, women in power and decision making. The fourth by Dr. Maya Trotz on women in the environment. The fifth by Ms. Sharon Carter-Burke on women and the media. And today we have the fantastic Tracy Robinson, who's going to be leading us through human rights, and specifically women's human rights. Now, while the objectives of the sessions, as everyone knows, are to identify the international commitments and jurisprudence in relation to the assigned theme, and to assess the progress made to date in outstanding critical areas in order for the Caribbean to be able to arrive at a shared position in relation to these issues, a shared progressive position. We recognize this may not be possible. We definitely hope it is. What we're going to be going through today is more of an understanding of what the human rights are. We're not looking directly at what the Beijing reports say. I think Professor Bailey went into that in detail, and many of you have seen the reports yourself. So I'm just going to introduce Tracy Robinson. Most of you know. She's a senior lecturer and deputy dean of graduate studies and research at the Faculty of Law at the University of the West Indies Mona campus in Jamaica. She's a researcher in the areas of constitutional law, human rights, gender, sexuality, and the family. Robinson is a co-founder and co-coordinator of the Faculty of Law UE Rights Advocacy Project, or URAP, with Arif Bulkan. She served as a commissioner on the Inter-American Commission on Human Rights, as well as the body's president from 2014 to 2015. At the IACHR, she was the inaugural rapporteur of the rights of LGBTI persons and the rapporteur on the rights of women. She was a commissioner on the recently concluded independent review of equity and health inequalities in the Americas, initiated by PAHO WHO in 2016. Ms. Robinson joined Mona Law in 2011 after teaching for a decade and a half at the Faculty of Law at the University of the West Indies in Cave Hill. Between 2005 and 2006, she was the Mauro Capelletti Global Fellow in Comparative Law at New York University Law School. She was a visiting lecturer as well at the Faculty of Law at the University of Cape Town between May and July 2006, and a visiting professor at the University of Puerto Rico Law School in September 2013. She has produced and co-written a number of regional expert reports on the law related to gender, sexuality, and human rights in the Caribbean, and has been involved in legal and policy reform aimed at furthering gender equality and children's rights in the Caribbean. In the last 5 years, she has participated in judicial education for courts serving Barbados, Guyana, Jamaica, Trinidad and Tobago, and the OECS on the themes of gender equality, human rights, and violence against women. And she gave the keynote address at the biennial conference of the Caribbean Association of Judicial Officers in 2013. Between 2003 and 2011, she served as a member of the Barbados Family Law Council, which is tasked with leading family law reform in Barbados. And in 2011, she was appointed a member of the Technical Advisory Group to the UN Global Commission on HIV/AIDS and the Law that delivered its report in 2012. Robinson was elected as a member of the 7-person Inter-American Commission on Human Rights at the OAS General Assembly in 2011, and is a rapporteur for the rights of women and the rapporteur for the rights of LGBTI persons on the Commission. She also served as the Inter-American Commission's first vice president between 2012 and 2014, and its president between 2014 and 2015, March. Earlier this year, Tracy Robinson received the prestigious Prominent Women in International Law Award, an initiative of the Women in Law in International Law Interest Group of the American Society of International Law, in recognition for her achievements employing human rights and international law to advance issues of gender and sexuality, especially during her tenure on the Inter-American Commission on Human Rights. She was also one of the honorees on the Gender Justice Legacy Wall launched at the United Nations in New York in 2017 on the anniversary of the establishment of the International Criminal Court to honor those who have contributed significantly to the field of international gender justice. So it's really a great honor for us to have Tracy Robinson leading this for us. So Tracy, without further ado, I will hand over to you.
It's a pleasure to have an opportunity to speak. I listened, Tony, in horror. I thought I sent a one-paragraph bio, and I'm sorry you had to hear so much of my past. But I can see that you're from all over the region, and it's an opportunity to talk a little bit about human rights today. So today the idea is that we talk a little bit about women's human rights, and I wanted to start the discussion by thinking about what are human rights first, in 4 different ways, and then why women's human rights. If human rights apply to all, why do we need to talk about women's human rights? And then 2 core concepts, equality and non-discrimination, which I think are really critical to the discussion about human rights of women and girls. And then to look at 4 areas. And I have a suspicion that some have been covered already. And you'll just shout out and tell me in the conversation or coming off mic, in which case we'll spend time talking about other areas. So on my 4 areas, yes, the 4 ideas which I'm interested in seeing anchor the women's human rights agenda, and let me say, ignore the phone call, that one is dignity, the other is self-development, the third is self-determination, and the 4th is accountability. These may be ways in which you have heard human rights described, but I think they cover some of the key set of issues which I think will come up in the Beijing Plus discussions. So let's take the first, which is dignity. You know, when we ask ourselves what are human rights, we're really talking about the entitlements we have because we're human. And the person about humans is this inherent dignity we have. And so you notice it in the Universal Declaration of Human Rights, the first article. All human beings are born free and equal in dignity and rights. That's really a core concept of the Human Rights Project. And it's echoed over again in all human rights instruments. So if you look at the St. Lucia Constitution, for example, usually you'll hear this in the preamble. You'll hear that the people of St. Lucia believe that all persons have been endowed equally by God with inalienable rights and dignity. And the inalienable covers the dignity as well. Take the Jamaica Charter, the new 2011 instrument. It says, whereas all persons in Jamaica are entitled to preserve for themselves and the future generations the fundamental rights to which they are entitled by virtue of their inherent dignity as persons and citizens of a free and democratic society. So dignity is very much the basis of the Human Rights Project and human rights. But I would say if you move from the basis to the goal, then human rights are about fostering human development. There's a strong connection between rights and development. The CARICOM Civil Society Charter, which I think is, despite its status as a mere declaration, a really important instrument for the region. It says states have civil and political rights, and within the limits of their resources, economic, social, and cultural rights, all of which derive from the inherent dignity of the human, and then also which are essential for the free and full development of the person. So there are a number of big ideas in that Article 3 of the Civil Society Charter. One is that the human rights are not just civil and political, but also economic, social, and cultural. Where do they come from? This inherent dignity, but what do they lead to? And what are they essential to produce? And it's the full and free development of the person. A number of us were involved in a case the CCJ heard last year, McEwen and the Attorney General. And that case is one in which the new president, in probably his very first case as president, Saunders, talks about a society which respects human rights being one which supports human development and the realization of the full potential of everyone. So in the large public discussions in the Caribbean about what are human rights, when you hear persons talking in terms which are absolutely inimical to the development of each person, in the way in which they imagine themselves, provided that doesn't harm others, then that's not a human rights agenda. That the goal has to be to allow people to develop to their best potential in the ways in which they imagine. And that comes maybe to one of the others which I'll talk about. So I've said something about dignity being the basis. I've also said something about human development being the goal. And then I want to also underscore it with self-autonomy. And that's not something you hear about often in human rights conversations in the Caribbean, but Justice Saunders made it clear that at the core of equality and non-discrimination is the idea that people should have autonomy, and that they should have some capacity to make decisions for themselves as to who they want to be and how they want to be. So self-autonomy, or what is sometimes called self-determination, is a really key element of the human rights project. And I signal this particularly in relation to sexual and reproductive health and services and rights. So some key ideas here is that the basis of human rights is the inherent dignity we have. The goal of the Human Rights Project is the full and free development of persons, and I would add communities too, because human rights can be collective as well. And the method is that one must decide for yourself, and sometimes that applies to communities such as indigenous peoples as well, that there may be self-determination not simply for individuals but also for groups. Maybe my other fourth idea is that human rights is a system of accountability. That's super key. That if you can't end up enforcing the right, it's not a human right. There must be some mechanism for securing accountability from those who owe it in respect of honoring, respecting, fulfilling the right. So human rights include these norms, which generally have a legal basis. Some of them are in our constitutions, those norms, but many of them are in ordinary laws, or sexual offenses law, or employment laws, or domestic violence laws. And then, of course, what is maybe of more interest to you here, they're also in international instruments like CEDAW, CRC, the Covenant on Civil and Political Rights, the Covenant on Economic, Social, and Cultural Rights, and so on. And then there are two elements of this accountability system: those who hold the rights, and that's every person, and then there are those who hold the duty to respect the rights, the duty bearers. And the duty bearers are both vertical and horizontal. So vertically really means the state and everybody connected with the state. You know, there's a well-known case from Belize, and I know we have Belizeans with us, in which a Catholic school dismissed an unmarried teacher who became pregnant. And the Catholic school said, "We're not the state. We don't owe a duty to this teacher. We're just a private church school doing our work." And the Court of Appeal and the Supreme Court rejected that idea and said, in fact, you are the state based on the way in which you conduct yourself, where you get your money from, the source of your powers, and therefore you have a duty to the teacher, just as if she were working in a solely government-funded school. That's vertical. But when you take it horizontally, individuals are also meant to respect the rights of others. This is absolutely critical to the human rights of women, because often the violations which women and girls face happen in private spaces and at the hands of private actors. And CEDAW, the Belém-de Convention in the Inter-American System, and other instruments are clearer than earlier human rights instruments that the duties extends to persons horizontally. And it extends horizontally and then goes back up vertically. So the state has a duty to ensure that other individuals don't violate the human rights of others. Good example is a St. Lucian case called Francois and the Attorney General, in which a well-known lawyer in St. Lucia was subjected to a protection order, an ex parte protection order, because his wife alleged that he had been violent towards her. He in turn complained that the orders were unconstitutional and the state was violating his human rights through this law. Justice Barrow, Belizean judge now on the CCJ, absolutely rejected that argument and said, in fact, the state of St. Lucia, by virtue of CEDAW and the Constitution, had a duty to protect women and others from domestic violence, meaning they had a duty to regulate the behavior of other private actors who could put at harm and who could compromise the right to life, liberty, and security of the person of women. So the accountability system on the state means the state must not just regulate what it does, but what private citizens do as well, and that private citizens have duties as well. So just to kind of reiterate what states are meant to do in a way in which you'll often hear in human rights terms. States have a duty to respect. They have a duty to protect the rights. Respect is often not interfere. Protect is often, to focus on legislative and other initiatives to address violations and fulfill often is an indication of very positive action which states must take to protect the human rights of all. I wanted to come back to, you'll see me say case study a couple of times, and it's invariably a reference to recent monitoring by the CEDAW Committee in the Caribbean. Both countries were reviewed by the CEDAW Committee this year. You probably know Rhoda Reddock is a member of that committee now, and before her, Barbara Bailey and others, including other Jamaicans, Kitishans, also from Bahamas. We had 2 Caribbean persons on the committee this year. Is that correct? I think so. So to give you a sense of how accountability works through the CEDAW committee, not in the same way in which it would work in a court. It doesn't apply to Martinez Francois in St. Lucia in quite the same way as when it happens before a treaty body like the CEDAW committee. But you probably, many of you may have been consulted or a part of the preparation of these regular reports to these committees and seen what they call their concluding observations. So noticeably, in the concluding observations on Antigua and Barbuda this year, you see very strong recommendations on disasters and climate change. This is certainly a strong thrust of all human rights bodies, making sure that the rights of women and girls are being thought through in developing policies and responses to disasters. Also notice the committee's observations on temporary special measures, particularly in political appointments in Parliament, but also in other spaces, and this is in respect of Antigua and Barbuda. There are recommendations about women accessing financial services, credit, savings, and family relations. I'm particularly interested as a family lawyer in their recommendations about the need for reforms to property laws, property distribution laws following divorce, and to ensure that there are regimes which properly protect persons who aren't married and women in non-marital relationships. For the Eastern Caribbean, this is key because nowhere in the OACS, the 6 countries, the independent countries, except in domestic violence, do you have meaningful protection for the property rights of women who are in long-term relationships or serious relationships other than a marriage. So my 4 key principles for human rights were that they're based on dignity, they promote self-development, the conduit or the methodology for getting from the first to the second is self-determination. You decide for yourself, and they must incorporate ideas of accountability. And these are 4 key principles for thinking about human rights. I wondered whether those 4 ideas about human rights resonated with any work you do. Is there any work you're currently doing where one of these elements is missing or many of the elements are missing, where this is key to articulating the human rights concern you have? It's the idea of dignity, self-development, self-determination, and accountability. Can I just ask that question?
Hi, this is Michelle. Morning.
Morning, Michelle.
Yes, I really like how you frame the 4 elements, but what I was looking at, I think that all of it's very cyclical and it goes right around if you think about it. However, if we start with something like accountability and seeing the present situation in most of the way how the state, our Caribbean, our individual Caribbean states, view how its citizens access any breach of human rights, I think it's not very accountable, because while there may be the opportunity to access, but the practical reality is not the case. I feel that when it comes to, for us to, if there is some violation of the rights and we need to seek a solution from the state, then it should be something that it's free for all, because you shouldn't have to have a certain type of economic class background or money to access justice or your rights. So at the end of it, then you're not able to have your dignity, you are not able to develop self-development and determination, because how do you then, even if you're very knowledgeable of all the conventions and everything, how do you, when you have a violation, ensure that the state does be the duty bearer?
Yes. Yes. So Michelle, one key thing for you is the gap in accountability.
Yes.
That you may have regimes which recognize the rights, but it's very difficult to secure accountability to protect, fulfill, respect the rights.
Yes.
Yes. I'm interested in whether others have that same experience, or you see other deficits where you are. For example, deficits in recognition of self-determination or self-autonomy, or for example, in basic dignity. Do you see any gaps where you can see one of these terms and ideas is really critical for understanding the particular challenges you face where you are? Accountability is a big one. No thoughts at the moment? Most of our countries, maybe about 3 or 4 exceptions, don't acknowledge that in every circumstance, a husband who rapes his wife has committed a rape. It's not a deficit in respect for women's dignity and self-autonomy, because the idea is that she doesn't decide for herself, that marriage has already committed her and provided her consent to her husband in perpetuity. Critical deficit in our laws, which go to the very heart of human dignity and self-autonomy as well. And also self-development, because we also know the relationship between violence and women's ability to be all of what they wish to be in life. So many of the issues we are grappling with on a day-to-day basis in respect of women's human rights are tied to these pillars. When we come to look at sexual and reproductive rights and each of the specific rights, we could come to a discussion of these as well. So let's move on and ask the question why women's human rights, which you, I think, very familiar with. And it is that we have been treated as second-class citizens as a matter of law, not just as a matter of fact, as a matter of law. Right now in the Bahamas, women do not enjoy the same citizenship rights as Bahamian men. In Barbados as well, there is no right against sex discrimination, prohibiting sex discrimination in the Constitution of Barbados. Women were denied even the most formal equality. For example, most of the Caribbean does not have anti-discrimination legislation that clearly and by appropriate standards prohibits discrimination on the basis of sex. And then in addition to that, we know historically the harms women and girls faced were invisible, ignored, and often doesn't have a name. Or the name all has a qualifier, like marital rape or date rape. Notice we still don't have words for harassment, which is a part of just life in the Caribbean. So it's this context and the fact that in reality women still don't have equality that mean that one has to not just talk about human rights, but to emphasize, as the Vienna Declaration and Program of Action in '93 does, a precursor to Beijing, that the human rights of women and girls are inalienable and an indivisible part of the universal human rights agenda. So it's that context in which we think about women's human rights. And then to also point out that women are diverse. And you hear the CEDAW committee, for example, in respect of Antigua and Barbuda, making it very clear that there's diversity in women, and some women are far more vulnerable to human rights violations than other women because of the intersection of multiple forms of disadvantage: migrant women, rural women, older women, women with disabilities, lesbian, bisexual, and trans women. For example, we could think of many more intersections. So it's key to think about women's rights as not necessarily meaning exactly the same for all women, but having different points of emphasis, different responses and forms of accountability depending on where women are located and their experiences and the disadvantages they face. I noticed in the CEDAW concluding observations this year, the committee actually recommended comprehensive anti-discrimination legislation that prohibits all forms of discrimination and ensures equal opportunities for lesbian, bisexual, and trans women, and recommends the decriminalization of same-sex relations between consenting adults. And it also recommends that the state ensure access for LBT women to employment, healthcare, and social services without discrimination or stigma. And 20 years ago, the CEDAW committee would not have been speaking in these terms, but it represents the committee's also its own development in understanding the diversity of women along the spectrum of sexual orientation and gender identity as well. So my two core concepts are equality and non-discrimination. And these are, in many sense, both straightforward and complex. We have, for maybe 30 years, as feminists, struggled to gain hold of an agenda which insists that equality means something which, for many of us, undermines women's development. But the CEDAW committee and other human rights bodies have been clear about their meaning, about their understanding of equality and non-discrimination. So let me start with non-discrimination. Discrimination could be very direct. For example, requiring husbands' permission for sterilization of women who are married. I don't know if that exists anywhere still in the Caribbean, certainly not formally, but perhaps informally. Does this exist anywhere where you are, where women are being asked to indicate that their husbands have agreed to them being sterilized?
Yes, I think this comes in form of a lot of times policy of the various maybe health institutions or health centers. And so while it may not exist in formal law, but then we also have to look at policy and where discrimination exists and denial of services because of certain either traditional, cultural, or personal belief of the institution or service provider.
Yes. Yeah, this is very direct discrimination. It's being targeted towards women and disadvantaging women, but you could have the discrimination being indirect. How many of you come from countries where there are height requirements for the army or the police force? Anywhere where that's the case? So it doesn't say you must be a man, but it says you must be 5 feet something inches, which is far more likely to be true of men than women. Anybody heard of these restrictions in countries you're from? No? Well, these restrictions still exist, and other restrictions which have kept, the already sex-segregated police forces and armies considerably still male-dominated. But it's indirect because it isn't targeting women openly, but it has a disproportionate impact on women. And you may have discrimination in law, for example, married women not enjoying the same citizenship rights as men, or discrimination in practice, as the example we gave of sterilization and requirements which are being made by various officials and functionaries that women provide permission from their husbands. So let me come back to the example I gave earlier of the unmarried teachers, women teachers who were fired in a Catholic school in Belize because they're pregnant. There was a similar such case in St. Lucia many, many years before. And my understanding is that there's still some places in which one can continue teaching if you're unmarried and pregnant. Is it discrimination if the school also fires unmarried male teachers who father children? Is that discrimination against women? So they fire the unmarried pregnant teachers, women, but then they say that they will also fire unmarried men who father children outside of wedlock. Do you think there's discrimination against women? And what kind of discrimination?
I think it's still discrimination because I think not because you do something discriminatory to male and female doesn't mean that it is not discrimination. I think that happens with us in Belize as it relates to when we look at turning out girls from school when they become pregnant. Because the idea is, well, we turn out girls, but we don't turn out the boys. And then some school says, well, okay, we can violate both men and boys and girls, and we can turn out the boys. So, but however, this right, like for example, having the right to decide if you want to become pregnant outside of wedlock, that as an adult, that's your right for self-determination. So how could that right then let you lose your job, which you also have a right to work?
Mm-hmm. Mm-hmm. Thanks, Michelle. Any other thoughts on this question of discrimination? Does this happen, maybe let me ask, does it happen unofficially in places where the school asks the teacher to not come back after she has the baby, or asks her to to resign early? Does this happen anywhere, or is this really from the last century? So doesn't happen in Guyana, doesn't happen in Trinidad and Tobago. If it did, would it be discrimination against women, do you think?
So I'm thinking, for the woman, you will get evidence that she's pregnant, huh?
Yes.
You will see her tummy raise or so. But for the man, there's no evidence of that. And the man can
Yes.
always deny the child and says
Yes.
not his child. So, of course, I
Yes.
think that the discrimination again will continue for women. Women will face it more than men.
Yes.
And this, we had issue in Guyana about 2 years ago, and I mean it was one of the fight that the Gender Affairs Bureau Guyana put up, where in the city of Georgetown they fired some what's called city constabulary officers because they got pregnant in the first 2 years of their contract, and we fought against it, and they revisited the policy. The women were re-employed. We also had the issue where the Guyana Defense Force, they were putting out advertisements just for male officers. So in the ad they were putting out, they were saying males only. And that's another
Yes.
fight that the Gender Affairs Bureau we put up. And we were successful in them removing that. And of course, females are now encouraged to apply.
Yes. Interestingly, the logic of the Chief Justice was that there's no way, the argument you presented, there's no way men and women can be in the same position here. Because it will be obvious that the woman is pregnant. It will not be obvious, the Chief Justice said, unless him do a sense and tell everybody that the man has fathered a child. And so in his view, it was evidently discrimination against women because women would always be disadvantaged by that rule and men would be unaffected by it. And the rule was not even-handed because pregnancy was a female condition, maybe a trans man too, but a female condition largely, and one in which women would always be the ones suffering the disadvantage. And what you have described are other ways in which employers signal a preference for men in what are already historically male-dominated professions. So interestingly, you're hearing courts saying that discrimination can happen in respect of pregnancy, which women experience. And so discrimination is not always about treating everybody the same. It is about acknowledging that women experience specific experiences which make them more vulnerable to discrimination. And so because of the example Michelle gave, I want to give another one, which is the Guyana case of McEwen. And this law said it was a crime for a male to be dressed in female clothing and a female to be dressed in male clothing for an improper purpose. And a group of us argued that was discrimination. And the government said in response, how can it be discrimination if it also affects women just the way it affects males? If it affects females just the way it affects males, can it be sex discrimination? What do you think? Did we get it wrong in arguing this was an equality issue, or did the government get it wrong? If the policy or the law deals with males on paper in the same way, women and men the same way, can it be discrimination? Any thoughts? Females dressing male attire for an improper purpose, crime. Males in female attire for an improper purpose, a crime. Can that be discrimination on the basis of gender or sex? Are you hearing me, Badu?
Yes, we're hearing you. This is Nicole from Barbados.
Yes, Nicole.
From a health perspective, I would have to say yes. If you don't know that the gender being displayed at the point in time of contact is the opposite sex, then yes, it can be discrimination once you once you find out, and especially if the person doesn't disclose for whatever reason, yes, this discrimination can take place. Because then if you begin to treat a female appearing to be a female in front of you for a female problem, but it is really a male, then you will begin to, I don't want to say automatically, but then when you find out, it puts a different spin on the situation for me as a healthcare professional. That's how I'm thinking. Because there's so many ramifications for that, because you could administer the wrong medication based on what's presented in front of you that can be harmful for that individual. So technically, depending, as I learned during this training this week, the law is such a funny thing that you leave room for interpretation for so many things to take place. That's my perspective.
So Nicole, is it discrimination, or let me just ask everybody, on the basis of gender identity or on gender?
It would be both. I think it would be both.
All right. So this is, anybody else has any thoughts on this one? The law, the crime applies to females in male clothing the same way it does to males in female clothing.
So let's look at this culturally. Generally, women will wear pants. And we using their analogy of what a female and male attire is. Right. So a woman will wear pants. And generally you have women pants, women, this sort of way. But for the man, there's no kind of skirt that he wears.
Right.
I mean, if you understand. So for the woman, there's pants that she's allowed to wear. And that's where the concern was. The concern was about the pants and dress or skirt. So of course it's discriminatory, because again, a woman walking to buy jeans, she can wear the jeans, it's okay. But for a man, the concern is also with him wearing a skirt or a dress.
Right. So your argument is, on the face of it, it looks neutral, but it can have a disproportionate effect on those who are in female clothing and are assigned male at birth. Because the expectations for male dress are more constrained than they are for female dress. Women, it is conventional for women to wear pants, but it's not conventional for men to wear skirts. And that notion of what's conventional is tied to gender stereotypes, and it's tied to patriarchy. It's that we have expectations that men hold their respective power through the way in which they appear to us, in ways that may provide more flexibility for women, but on the other hand, women face high sexualization based on attire as well, and irrespective of attire. So interestingly, here is what President Saunders says. Two possibilities here. Persons who are assigned male at birth but assume female identities or are female in their own sense of selves, or simply are wearing female clothing, are worse off. The second way in which he was interested in looking at it is everybody's badly off. And why are they badly off? They're badly off because of gender stereotypes about what it means to be female and what it means to be male. And his idea is those stereotypes impact our self-development and our self-autonomy, and therefore are unacceptable. So he does accept its inequality. And it's inequality on the basis of gender, even though both males and females are affected. In other words, the more profound the gender inequality is the more it will affect both. There's a Kitishan case I'll talk about quickly, and I'm watching the time. It's a little boy who goes to primary school in St. Kitts at 4 years old, and he has a ponytail. I don't know what it is in the rest of the Caribbean, but in Jamaica, for example, we generally don't like to cut boys' hair until they start speaking. So boys often are wearing plaits all through their toddler years. This boy continued to have his longer hair as he went into primary school. What do you think the primary school said to him in St. Kitts? Can anyone guess what the primary school said?
Cut it.
Yes. Yes. Cut it. Come
Yes.
with short hair. Our
Say-
rule says boys must have short hair. That was what they said. And he said, I think that's sex discrimination because girls don't have to have short hair. The court then said, well, actually, the rule is the same for girls and boys. It's that they must wear their hair conventionally. The girls must have conventional styles and the boys must have conventional styles. And interestingly, the Court of Appeal said there was no discrimination on the basis of sex. Do you think they got it right?
No.
No, they did not.
Okay,
So
why not? Why not?
What about a girl who is bald? Will they send her home too and said, come back when your hair is growing?
Sorry, I missed that. That's a hard one, Nicole is saying. But listen, is the role of human rights and equality to tell us to conform?
Tracy Adele was asking if there's a girl child with a low haircut or she's bald, like for whatever reason,
Yes.
her hair doesn't grow. If she'll be sent back home and told, come back when your hair is able to go into the conventional style. And what is the conventional style? Is that along European standards?
Yes, very interesting. Again, this has changed, but I remember growing up and being told your hair should not be combed for school in more than a certain number of plaits. And because those of us who have African hair cannot wear hair in one plait, most of us, if we do, it wouldn't comb the next day. People were forced to straighten their hair. So what's conventional tended to be both raced and gendered. And so very interesting question from Adele. And maybe the proper answer should have been, why are we forcing girls and boys to wear stereotyped hairstyles for girls and boys? Why are we fitting young people into boxes about who they should be at age 5? And why for a boy who we know would suffer psychological harm when a key part of his self-definition, his identity, was taken away from him? Why should schools be in that business? So the very business of forcing people to conform, to fit in to what is already stereotypes about masculinity and femininity, which fit into power hierarchies, which we know contribute to inequalities and violence, we should be, if we believe in human rights, respecting self-autonomy and development, at the same time as trying to protect, to a reasonable degree, order and protection from harm. And so the proper answer might have been, shouldn't there have been rules which gave greater freedom for persons to come to school with long or short hair as they wished, whether boys or girls? Yes, go ahead.
Yes, for sure, Tracy, this very topic hit home for me personally. My daughter had a disease, a skin disease that actually required her to shave her head. And so she got a lot of bullying and teasing because she had to, because of the disease, she had to shave her head. We didn't have an issue at her school at the time. However, my son has locks, and when he went to enter high school, they kept him out of school for 70 days. They actually went into the classroom, took him out every time because they said that he was not allowed to come to school with locks. So I faced this on for both my daughter and for my son. And it really shows how gender stereotype is so ingrained. Well, we ended up challenging the case and going to the Supreme Court of Belize, and the Supreme Court said, of course, he had never cut his hair from he was born. His dad is Pan-Africanist, Rastafarian family, we are. And so with those tenets, he was based on religious freedom and cultural freedom, he had to be admitted to school. But this caused trauma to both my daughter and my son. although we try to, they live in a family that is very supportive, but then the bigger aspect of gender and identity and gender ideology impact, and these social constructs impact these young people. And sometimes, of course, they have to forge their way through a society that is very discriminatory, that does not allow self-expression, that does not allow self-autonomy. And even though they're very bright, they're able to contribute to the society in a very positive way. And so I think these laws are so antiquated, and they're so based on our colonial history and past, and we hold on to these things as if they're the truth, and as if these young people will become the most maligned, depraved serial killers in our community, and none of this is true.
Yes, yes. So this is why I'm talking about equality and non-discrimination as core principles. And there's some of what I have after, which I'll skip. But what I want to say to you is that people are always telling us, you know what equality really means? You must behave like everybody else. Haven't you heard that? There are rules, and equality means that you should conform to the rules. That if you conform to the rules, then you'll be treated exactly like everybody else. But if there is self-determination, if people get to choose, if you should be able to wear locks as an African descendant in the Caribbean, whether or not you're Rastafari, should the schools be telling children that you can't wear locks to school unless it's for religious reasons, for example? Notice the combination of race and gender here together, that it is not simply gender shaping or expectations of what people should be, but also race shaping them together. And we are noticing that people are often telling us equality means conformity, treating everybody the same, and the same is a stereotype. The very stereotype which has produced the inequalities for us. So I wanted to present an idea of substantive equality, which says that we must look to the reality. We must look to all aspects of people's lives. We must tackle the stereotypes. And the worst inequality, gender inequality, impacts both males and females. And that is, I think, the massive insight of the CCJ, that sometimes gender equality is so intense that you see the way in which the norms are shaping and limiting both the self-development of both males and females. The CEDAW committee also presents ideas of substantive equality as equality of opportunity, giving women an opportunity to be empowered to reach the same results, and also a transformative dimension, which is it should change the structures. How can we tackle inequality if we don't tackle the structures of stereotypes and expectations of men and women? So substantive equality is not simply about treating everybody the same. It is about recognizing the root causes of inequality and addressing it. Sometimes, for example, despite the number of women in university in the Caribbean, the poor representation of women in parliaments, for example, may require positive action temporarily to address those disadvantages and to tackle the inequalities. So you heard Justice Saunders in the CCJ case say substantive equality may sometimes mean the same treatment. It may mean different treatment because people are differently circumstanced. And it may also mean special treatment, because that's the only way of addressing a historical inequality. So to move on now to my 4 key areas, and I wanted to show you, some concluding observations from Guyana now, which talk about gender stereotyping, this notion of trying to promote equal sharing of family and domestic responsibilities, so tackling the private and public sector as well, ensuring there's paternity. Jamaica is in a debate about which men should access parental leave, for example, ensuring there's affordable and accessible childcare. These are all very specific measures which will significantly impact the equal sharing, but also allowing women to have great opportunities in a range of spheres, including employment. The legal definition of single mothers came up in the Guyana CEDAW hearing. And then the regulation of the informal sector. You know that women are disproportionately represented in the informal sector without a range of benefits, including social security benefits. These are all measures which are designed to produce substantive equality. They're not simply saying, does the rule treat men and women exactly the same? So my 4 key areas were women in public and political life, rights of women and girls to education, and I suspect Professor Bailey discussed that, sexual and reproductive health, and access to justice, not access to education. That's an error. I won't say much here because I think you're all well versed on the standard of equality requiring equal opportunities for both men and women to participate in political and public life. And do any of you come from a country where we have 40% of women in our parliament? Any of you? Have any of you noted increasing numbers of women represented in parliament where you're from? Have any of you noticed a drop in numbers?
Guyana's close there. We have 37%.
This is Guyana, where you do have positive action.
Right.
Yeah, so Guyana does have some measure of positive action to strengthen women's participation, and it's not surprising Guyana has the largest numbers, but I'm seeing Jamaica is dropped, Belize is dropped, others have dropped, even as we're being told how well women are doing. Notice the specificities of, sorry, go ahead.
Grenada has increased. We are at 47% in the lower house.
Yes, so Barbuda now is at 40% with the last change in government, and Grenada. So we have 2 countries that have gotten to 40%. Hi, go ahead.
This is from Antigua. What we're noting too in Antigua is that we saw that there was an increase of women in the upper house in parliament.
Yes.
Which is appointed. So that's just something that we can note as well.
Absolutely. Thanks, Pramala. That's very, I mean, I think many of us noticed it in Antigua and Barbuda especially. But it's true in other places that there's definitely greater representation in the nominated house as opposed to the elected house. But we know the persistence of gender stereotyping and the gender division of labor in political work, but also gender-motivated violence against women who are engaged in political work as well. On the right to education, since Professor Bailey has already discussed this, did she talk about General Recommendation 36 of 27, which she was, I think, the key drafter of? Well, this general recommendation focuses on 3 elements of the right to education, and the right to education is often one of the difficult areas for discussion around gender equality because everyone focuses on numbers. And it talks about the right to access to education, which includes, but it goes beyond the question of numbers. And equal representation in numbers. So it's this idea that education should be thought of not just as how many women and men are in, for example, tertiary education, but rights within education, which is the rights to equality of treatment and the nature of gender relations within educational settings. So many of us know that despite women's strengthened educational or better educational achievement at some levels, that they're still facing sexual harassment in schools. That within the teaching profession in schools, we're still seeing gender discrimination with a higher echelons of the profession being dominated by the minority of men in the profession. It's those gender relations that we hear women and young men learn in schools. So rather than girls and boys learning gender equality in our school systems, despite the improved performance of women in the educational system, they're learning inequality. And that's why they also talk about the rights through education. And so these three ideas, I think, are really central. This idea that education is beginning to shape how we think of the universe and world, and that we notice that despite the educational accomplishments of girls and women in the educational system, that when they move out of the educational system, that what we see is inequality in employment and other spheres, and that the certification doesn't carry the same value and social currency for women and men. That men are still occupying better positions despite the educational attainment, and it means that therefore the rights through education are not equal for males as they are for females. On sexual and reproductive health and rights, I think the key to remember here is that all the human rights we enjoy, economic, social, civil, political, are connected to the sexual and reproductive health and services and rights which we are entitled to. So it's not as if this is a new set of rights. They're connected to the right to life. Women still die in the context of unsafe abortions in the Caribbean. It's the right to health, it's the right to privacy, the right to education, the prohibition of discrimination. And you're hearing from all the human rights bodies and treaty bodies, special procedures, the importance of sexual and reproductive health and rights. The Committee on Economic, Social, and Cultural Rights that articulates the right to health says the right to health includes sexual and reproductive rights. The Special Rapporteur on the right to health points to the importance of reproductive health services, adequate in numbers, accessible physically and economically, and accessible without discrimination. The CEDAW also speaks to rights to reproductive health and services, freedom to choose on how you want to have your families and when. The Beijing platform, also, one of the areas of deep dispute is about women's human rights in respect of their bodies. All throughout the human rights system, there is this echoing of self-autonomy, your ability to make decisions for yourself. So notice as we get close to the end, and let me leave the 15 minutes at the end for us to continue talking, that the CEDAW committee to Antigua and Barbuda instructs them that the CEDAW obligations of Antigua is a party to CEDAW, that those obligations require it to incorporate in its curricula mandatory, age-appropriate, comprehensive sexual and reproductive health education. That's part of its treaty obligations under CEDAW. That education for girls and boys should be rights-based. It should address issues of power, sexual behavior, prevention of early pregnancy, contraception. Not only that, they have told Antigua and Barbuda, and will tell every single Caribbean country the same, that they should legalize abortion in cases of rape, incest, threat to the life or health of pregnant women, and severe fetal impairment, and decriminalize it in all other cases, and ensure access to women of safe, high quality, and affordable abortion care. Very quickly, to just say on access to justice, that the CEDAW committee in general recommendation 33, I talked about 36. 33, I think Prof. Bailey may have been on the committee then, has these 6 ideas about access to justice. It's justiciability, its availability, its accessibility, its good quality, its effective remedies, and its accountability, and the need to both tackle discriminatory laws and bias and stereotyping in the system. And I wanted to end with 15 minutes to go by mentioning a couple of things the CEDAW committee told Antigua and Barbuda. And not, for the Antigua and Barbudans, I know Farmal is on. This is the reason I mentioned in Antigua and Barbuda and Guyana is because they had recent reporting and responses from the CEDAW committee in the last cycle. And so the CEDAW committee tells Antigua and Barbuda that it should increase the allocation of financial resources to the model court on sexual offenses, which I think Farmala is involved in, with a view to improving the efficiency and effectiveness of judicial proceedings and ensuring access to justice for women, including protection for redress for violations of their human rights. And it recommends, and this is a critical dimension of access to justice for women and girls, it should increase and expand the legal aid services to include free legal aid for women and girls who don't have the means to pay for it, and legal representation for women and girls in criminal cases relating to gender-based violence. It means that if you are a complainant in a rape case or another sort of sexual offense, you should have access to legal representation. That would be groundbreaking in the Caribbean. Your thoughts on any of the core elements of human rights or the 4 areas I've looked at: access to justice, which was highlighted very early on as a key concern in the Caribbean, the accountability gap, the impunity gap, the question of education, and whether education is in fact transforming women's lives, ensuring their own self-development, and creating a world free from gender discrimination and gender violence. We also looked at political participation and the deficits in women's political and public participation, despite high levels of educational accomplishment. And we also looked at sexual and reproductive rights, one of the most controversial areas, but deeply connected to dignity, autonomy, self-development of women. Thoughts on any of the areas we talked about? Of the 4 case studies, or not 4 case studies, of the 4 areas I looked at, which is the one I haven't discussed that you would say is a big priority? It might be climate change and disaster relating to women. What are some of the areas you think we should be closely focusing on in the context of women's human rights and girls' human rights? What are your thoughts on sexual and reproductive health and rights?
Nicole from Barbados, I think we need to pay closer attention to the disaster aspect because of the movement of people within the region, the trauma that takes place, and the things that they can be exposed to because of having to move, not just the trauma physically, but emotionally and every aspect of trauma. I think we need to pay closer attention as hurricanes and storms and all these other natural disasters are taking place within the region, and that constant movement of persons between islands, the different cultures, the different ways that persons are doing things. I find even in healthcare is having an impact, not necessarily a bad one, but we need to be a lot more cognizant of the impact that the disasters are having on the region. For women especially.
Yes, one of the, when I was at the Inter-American Commission, I spent a lot of time monitoring follow-up on a precautionary measure the Commission granted to women in Haiti following the earthquake. Many of you remember the high risk of violence, the increase in violence in camps, in temporary camps, which women and girls experienced. Do we have data on the risks to women in the disasters we faced in Antigua and Barbuda, in Puerto Rico following the hurricanes a year ago, in Dominica. Do we know what impact it had on women's health and safety? Do we know if precautions were taken? You can tell me. You're all based in some of these countries. Are we attending to the risks of which we are very well aware to women's safety and health in the wake of disasters, and particularly in the context of sexual violence and other forms of gender-based violence? In Antigua, for example, and Barbuda, is there data, not just on numbers of deaths and injuries generally, but also, and I've seen Elaine's question, but also on disaggregation by gender and type is one of the questions I'm asking. Elaine is asking to clarify between rights, freedoms, and privileges. So, Elaine, where are you? If you don't mind me asking.
Grenada.
In Grenada.
Yeah, Grenada.
Yes, I would say privileges doesn't enter into the human rights language. So the idea of a human right is not one of a privilege. So I would say if you were to put the two on a board, there would be an X between them. A human right is an entitlement. And so it is something which you enjoy just because you're human. It's not a privilege you have. So the word freedom, I think, is, if you were to put this in a board, it would be a subset of human rights. So freedoms would be one way of thinking about some human rights, but not all. So for example, the right to education can't be thought of in terms simply of a freedom. It's really a substantive right which requires the state to do many things to allow you to enjoy it. So some human rights could be described as freedoms, but not all of them. And often the economic and social rights, like the right to education, to health, aren't easily understood as freedoms. Whereas some of the civil and political rights, like the right to be free to express yourself, the right to be free to move without impediment, the right to practice the religion you want, are more easily understood as freedom. So if I go back in the slides, this slide, that the question of respecting rights, often you could use the language of freedoms to describe the state's duty to respect. It's often respecting a particular freedom you have. But when you move to fulfill and protect, the language of freedom is often inadequate. And so Nicole is pointing out that there isn't enough capturing of the data relating to the impact of disasters on women and in a context of gender inequality in the Caribbean. We're not paying enough attention to it. I certainly noticed, in the high visibility of the Puerto Rico data internationally, we heard less internationally about Antigua and Barbuda and Dominica. I saw virtually no gender disaggregated data, no data on violence against women.
Yeah, that was hard to get. We tried to get that information. It was very difficult to get. It was very difficult to even get sex disaggregated data for who was actually in the shelters. So that's a real challenge. Yeah, go ahead.
Yes.
I wanted to add, I think the question was asked too about Antigua's experience, and just to support to what Tony said, in Antigua, you were asking about whether or not we had disaggregated data for the damages and so forth. So the only information that we've been able to look at that for the post-disaster needs assessment report that was done where we were basically looking at the state of affairs prior to the hurricane, and then looking at post-hurricane. And so that would basically be dependent on the data, the quality of the data that was existing across the sectors prior to the hurricane, and then looking at what we were able to collect from the persons who were within the shelters. Because for the Barbudans, all of the Barbudans were placed in shelters. A few of them were staying in private homes. And so we were only able to capture the information dependent on those who were in the shelters, basically, to get a sense of how they felt about their safety, their economic empowerment, and so forth. And all of that would have been captured under the social and gender aspect of the post-disaster needs assessment that we did in collaboration with UN Women and so forth.
Yes. So the question
Tracy,
of
is Sharon here. In terms of the shelter management and protecting women, I think the state usually, well, in Barbados, they have principals of schools as the shelter wardens, and teachers are supposed to report to the shelters they are supposedly assigned to at the beginning of the school year, upon the instruction that the shelters are open for the public's access. I have never heard of teachers being trained to manage shelters, and to manage shelters in a way to protect women and to protect children and to protect men, or to protect anybody from being a victim. They have their Teachers Professional Day, which is focused on the teaching profession, and I have not seen in Barbados, and I don't know about the other islands. And if we want to get serious about this and the state taking on the responsibility, this is training that needs to happen.
Yeah. I'm noticing this question of data comes up as a method of accountability, but also protection. And so it's also about what policies are being developed. And I understand that the CEDAW committees asking Antigua and Barbuda that in the wake of the hurricane, to ask itself, is it giving due regard to the rights of women and girls as a primary consideration in devising measures to address disaster response and risk reduction? And that includes some of what Sharon is mentioning in the planning of shelters, but also it is how one collects data during disasters, and how one responds to the specificity of the situation of women and girls during disasters. And I think all of us are seeing that this is an urgent need for concern in this new millennium for Caribbean women and girls, and that we see an invisibility of these issues while we are in the midst of crises, and even after in trying to make sense of them. I'm hearing from Tanya at UN Women that they tried and had difficulties. I'm hearing from Farmala in Antigua, they had difficulties. But it's telling us something about what needs to be done, something you might be thinking about as you move towards the Beijing Plus process. So I'm trying to follow the comments. Maybe for our last couple of minutes, if you go on, if you come on mic in speaking, because I'm probably can't catch up with everyone in the couple of minutes we have left.
Tracy, I can read some of them, and I also would like to ask that we do go back to the question that you initially asked around sexual reproductive health and rights, because that seems to be a major sticking point for the Caribbean around Beijing Plus 25. And you have given us some very clear examples where the jurisprudence is moving in a very particular way, yet during the negotiations, one of our biggest challenges is that the legislation for most countries is not. So how does the human rights framework and what countries have ratified under CEDAW and all of these other things then play a role, we'd say, in the negotiations? But before you get to that, Elaine indicated that the Grenada Constitution has a chapter on fundamental rights and freedoms, and then you responded. that all constitutions use that formulation, fundamental rights and freedoms. Nicole Aline indicated that it affects goal 3 of the SDGs, and I think this is where she was speaking about both pre and post disaster. And Elaine has said she's heard the argument that it is binding on the state, not private actors. However, you have stated that the state has a duty to regulate others. Please share further detail.
Yes. So let me take so a couple of comments. The point I wanted to make on the Grenada formulation is that freedoms are part of rights. It's the way in which we are formulated, but most places the freedoms are one dimension of the human rights rather than something separate from human rights. How does it work in the private sphere? And I think that case of Martinez Francois, which every one of us should read, I'm happy to send it on to you as well. It's not a terribly long judgment, but in it, Justice Barrow, as he then was, said, here is this big lawyer, big public lawyer in St. Lucia who has come to me and complained, and yes, I will, he has complained that we are discriminating against him. His right to talk to his wife as he wishes. He was told not to harass her. The fact that the order was given without his notice in the beginning. And do we have a duty as a state to regulate what private citizens do? And that connection which Barrow makes is one of the most fundamental connections made in Caribbean human rights law. He says the Constitution is not just regulating what state actors do, what the police does, what the teacher in a public school does, what the government official does. He says the duty extends to the state protecting your human rights by addressing what private people do to you, because for women, many of the violations are at the hands of private actors. So the state must regulate what private persons do. And that was, I think, the first time in such explicit detail a Caribbean judge made that connection in our constitutions. So I would say, as a matter of domestic law, in Grenada, in Barbados, in Jamaica, in St. Lucia, the responsibility or the right that women have to life means the state must do everything, I think Roberta spoke about this, to exercise due diligence to prevent your intimate partner from killing you in the name of love, or in the context of what should have been a loving relationship, and to prevent you in your private employment from someone harassing you. Even though it's private employment, they must pass legislation to address that issue. So the state must pass laws that regulate the private sphere to protect against violence and to address it, investigate it, punish it, and repair us when it happens to us. That's the idea. And that idea exists in international law and by virtue of the Francois case at the domestic level as well. Can I say something about sexual and reproductive rights, which Tanya has mentioned, and I think Lana has also mentioned, the way in which Caribbean countries keeps locking. So we know that Barbados and Guyana have made some advances in respect of the legislative framework, for example, for a safe abortion. But here's what the CEDAW committee says. The CEDAW committee says a safe termination is a service women need. And I think that's a more than fair assessment. And if you deprive women of a service they need, you are discriminating against women. So the question could be, well, what should Caribbean policymakers, lawmakers, some of you who work for the state, how should you understand this issue? Yes? I mean, what can my government reasonably argue? Well, your governments must argue that the highest law is what? What's the highest law for all of us? The Constitution. So the fact that there is another law, a piece of legislation, that does not respect the rights of everyone is not the end of the story. It's the Constitution which matters. And so we have to ask, well, what do our constitutions say about the issue of sexual and reproductive rights? Well, they say women have a right to life, to security of the person. Unsafe abortions impact the right to life and security of the person, security over their body, women's bodies. The question is, do women have a right to non-discrimination? There are challenges in the Bahamas and challenges in Barbados in that argument, but everywhere else the constitutions are pretty clear. The CEDAW committee argues that denying women a service they need amounts to discrimination on the basis of sex. Well, what's the status of the laws which we have? The same status that the mandatory death penalty had until people challenged it in the courts. Once people started challenging it in the courts, not one single country except Trinidad and Tobago has been allowed to retain the mandatory death penalty because it violates the constitutions. And my assumption is that at some point, women will question these laws, including on the basis of their right to privacy. The right to privacy, the right to self-determination and autonomy, the right to equality and non-discrimination, the right to life. These are all central elements. So there are a couple of things. Caribbean laws criminalize, with some exceptions, at common law generally. But you know what the problem is with the common law exceptions? When you need a safe abortion from the state and you go to the hospital, what are they going to tell you? I don't know how that works. I don't know how it applies to me. I don't want the police coming for me. And invariably, they don't provide the services in the ways in which women need those services. And so even in our countries where there are exceptions, those exceptions should be written into protocols that guide the actions of state officials so women can access safe terminations. Ghana is mentioned in the role of the churches, and that they're bowing to the churches. Absolutely. We've seen across the Caribbean how constitutional provisions in Jamaica have been included largely at the behest of particular actors who have advocated firmly for them, who are connected to churches. But interestingly, I've noted in Jamaica how feminist Christians have also indicated the value of safe abortions and access to them for women. And I think it's very important in the face of the resistance, which addresses in negative ways the questions of dignity, autonomy, self-determination, that one begins to represent and make clear that the church is not a monolith, that there are many different positions and views within the churches throughout the Caribbean, that it's not one institution. It is a collection of people who have different views, and that was our experience in Belize when we started the Orozco litigation. As we started with opposition from almost all churches to arguing an appeal in 2018 in which not one church was involved in the appeal against the positive decision decriminalizing same-sex sex in Belize. So I think there are opportunities to continue the conversations, which I see happening around the Caribbean. It's essential. When I was on the Inter-American Commission, there was this big debate about the right to life and an important case from Costa Rica. And how does the right to life of the unborn fetus or the embryo match up against women's? And the court, in a really important decision, and I can try to share a summary of this if you find it useful, said that it isn't that an unborn fetus has no rights. That's not the argument at all. It is that when one weighs those rights develop incrementally and must also be weighed against the interests of women on the whole, or of parents on the whole. And so it was not either or, but they made the strong claim that the right to life is a right which develops incrementally prior to birth and does not exist in the same way after birth as it exists prior to birth. So we're at 10, and I'm sure to be wrapping up now. It's been a pleasure to chat with you. Look forward to seeing you and meeting you in other spaces as well. Thank you so much, Tani.
Thank you very much, Tracy. This was, as I think we all knew, it was really, really informative and just as fantastic as we knew it would be. Thank you all for joining on and bearing with us through our technical difficulties. I hope this was as meaningful and useful for you as it was for us, not only this session, but all of the 6 of them. So thank you all. Thank you, Tracy. Have a wonderful trip to Belize. I know Michelle is looking forward to having you there. And everyone have a great weekend. As we say, we like work-life balance here, so please enjoy your lunch, take a break, and we'll get back to the work of women's empowerment, gender equality, and human rights.